So hello and welcome back to part 2, Contract Law in Privity of Contract. Okay, so last time we were actually looking into exceptions into the Privity of Contract, right? So there are recognized exceptions to the doctrine of Privity of Contract. First one is agency, assignment of contractual rights, trust, collateral contract, tort law. Okay, under these exceptions, a person can sue or be sued under a contract even if they are not a party to a third contract, to a party to the contract. Okay, so let's go to the first one here. Agency. Number 1, agency. The agency rule is when the agent acts on behalf of the principal and is able to enter into a contract. The agent is able to create a legal relationship between the third party and the principals. The contracts entered by the agent are binding on the principal. In the case McConnell versus maybe McLaurin Motors Limited, the manufacturer was the agent between several dealers. Each dealer entered into a contract with every other dealer concerning the matter of territories. Dealers are able to sue other dealers. New Zealand Shipping Company Limited versus AM Saltwaite and Company Limited. This is a case about the sales of equipment to be carried by sea to the purchaser. The seller entered into an agreement with the shipping company. The bill of lading would release them from any liability for any loss or damage. Thus, the carrier's liability has been limited. The purchaser received the goods in poor condition due to the negligence of the company who moved the equipment. Steve Dorr was hired by the carrier to unload the equipment. The purchaser sued Steve Dorr for negligence. However, Steve Dorr would be protected under the bill of lading. The court recognized that there was an agreement that any independent contract shall be protected as stated in the bill of lading. Alright, the second one, we'll look at trust. Number 2, trust. A trust is when a property is given to an individual to hold and manage for the benefit of another individual. A trust is a separation between the legal and beneficial owner. A trust is created by the settlor who gives the property to the person managing the property. This person is known as a trustee. The trustee is the person who has the legal title of the trust. The beneficiary has the interest in equity and the interest is enforceable against the trustee. The legal interest belongs to the settlor. Another case we should also look into is Van Depite versus Preferred Accident Insurance Company. Alright, so the law of trust to a third-party beneficiary contracts case is vulnerable to the charge that no genuine intention to create such a relation is evident on the facts of the case. Page 304. Third type we want to look into is number 3, contractual contract. Collateral contract, sorry. This type of contract allows the consumer of a party to be a third-party beneficiary of a manufacturer's guarantee contained in the contract of sales to the dealer. It enables the consumer to enforce the manufacturer's warranty directly. The consideration of this contract is the entry into the purchase contract. By purchasing a product, you've got consideration to the collateral contract with the manufacturer. This type of contract coexists with the main contract. Shalskin Pier Limited versus Detail Product Limited. There was a collateral unilateral contract offered by the manufacturer to the plaintiff. The manufacturer had informed the plaintiff that the unsatisfactory quality of paint. When the plaintiff instructed the contractor to use the paint, to use the paint on the pier, the plaintiff accepted the manufacturer's offer that it would be bound by its representation concerning the poor quality of the paint and gave consideration that made the manufacturer's warranty binding. Page 304. Okay, so the fourth type, number 4, tort law. This type of law that deals with civil wrongdoing that was developed from contractual obligation. If a person suffered illegal damages, he may sue. He may use tort law to receive compensation from the party responsible for the damages. Old English case Donahue versus Stevenson is an example. Alright, ginger beer had a decomposed snail in the bottle. Donahue sued the Stevenson. In Donahue versus Stevenson, Mrs. Donahue was not a party under the contract. The party under the contract was the shop owner and Miss Donahue's friend. Miss Donahue's friend purchased the bottle of ginger beer for Miss Donahue, and Miss Donahue found a partially decomposed snail in her drink. Since Donahue was not a party to the contract, she was not able to sue under the contract. However, it was ruled that manufacturer owed a duty of care to the customer. In the end, Donahue was awarded damages in tort. Okay, number 5, assignment. Assignment of contractual right is like the property. This property can be transferred from one person to another. It is the ability to transfer the right of a property held by one party to another. The person who is transferring the right still remain liable. The person receiving the property is not liable. However, the contractual right will still be enforceable against the original promisor. The benefit of the contract are transferable to the third-party beneficiary. If the signee transfers the benefit to the third party may enforce the contract as an assignee. Okay, number 6, statutory exception. There are some statutory exceptions to the third-party beneficiary rule. One example would be in the context of insurance. The beneficiary under a life insurance policy has a statutory right to enforce the policy. In the motorized vehicle insurance, the victim of an accident has the right to claim against the insurance company of an individual who had caused the problem. There are also rights of a mortgagee to sue against the assignee of a mortgage. There are also statutes that will allow consumers to enforce the warranty of manufacturers. Alright, so number 7, additional exceptions at common law. So, A, provision limiting the liability of employee. McCamus states that harms to the customer results from the careless conduct of the employee. The employee may be immune from the liability, but this immunity would not be extended to employees because they are merely third-party beneficiaries of the contract between the employer and the customer. Page 308. In the Greenwood case, there was a lease agreement where the leaser agreed to take out fire insurance and not seek compensation from the lessee in event of a fire. However, the leaser was successful in enforcing directly against the lessee's employee who caused the fire. The provision in the contract had no intention of protecting the employees. Alright, in the London Drugs Limited versus Nagel International Limited, London Drugs contracted a storage company to store its transformer. Through the negligence of 2 employees, the transformer was damaged. London Drugs sued the 2 employees of the storage company who was storing the London Drugs transformer. The Supreme Court of Canada recognizes that the doctrine of Privity of Contract that prevents beneficiaries from enforcing a contract to which they were not a party to. The court made an exception in this case of the employees. Quote, "It would be absurd to let the appellant go around the limitation of liability clause by suing the respondent, so employees in tort." Page 309. The employee will not be liable. The doctrine of privity of contract should not apply when there was a limitation of liability clause and where the employee were carrying out its duties under the contract for the customer. Alright? So, that is it for Privity of Contract, Chapter 9. Until next time, we'll look into more fun stuff. So, stay classy, alright? Thank you, and thank you for listening.